Okay, so we'll switch to English for Matthew Goodman, who doesn't fluently speak French. He understands some of it, but and he flew from New York to participate to our roundtable. So thank you very much. So maybe Matthew and Olivier to start. Do you have like a general statement about the suggestion from the mission d'information that Clément mentioned, that you want to start with at the general level, and then we'll dive a little bit into each proposition or some of them. Thank you. Do you want to start, Olivier? Okay.
Du coup, vous voulez que je réponde en français ou en anglais?
En anglais.
Okay. So first, thank you very much for having us today. What I want to say about the Eric Verse report is, I mean, to us, it seems very fair, first, and we are fully in line with a lot of the recommendations that we find. You mentioned it in your introduction. In France, we have a tendency of, creating new laws all the time, and the main outcome with this report is clearly that that's not the case here. So I think it's positive. There's maybe a couple of remarks as an introduction. The first one is, and you mentioned it, there's like a huge number of activist campaigns in the US. I think since the beginning of the year, we have like more than 150. In Europe, the vast majority of the campaigns are in the UK. It's like 20 since the beginning of the year. And in France, it's like 4 or 5. So, I mean, we do talk a lot about activism in France, but just to put things into perspective, it's like 3, 4 campaigns since the beginning of the year. The second remark, and you mentioned it, the definition of activism is very difficult, and it's a lot of different strategy and different kind of funds that you will find within activism. For us, as an example, we're a value fund. We invest mainly in continental Europe. We, in the vast majority of the investment that we have, we want to create a dialogue with the management, and that's key for us. And in the vast majority of investment, 95% at least, we have absolutely no conflict with the management, and we've been able to create a very good relationship in which maybe if we don't agree on everything, we can at least exchange and debate about our views. The issue, obviously, and it becomes more mediatic, it's in the 5% of the case when you debate with a company and they refuse to listen to you, or they don't want to listen to you, it may become more problematic. And then it's true, you have 2 choices for us. Either you just sell your shares and you go and see another company, or you want to defend your right as a minority shareholder. You think that you have a voice, and it does make sense for the company, after all, to listen to you. And that's the 5% of the case that become more problematic. Maybe one, not discrepancy, but difference that we may have with the report. If you look at the European markets, and we do invest in continental Europe, so we do see the differences between the different countries. In France, we, the regulator or the country in general, has a tendency to favor the corporates against the shareholders. That's our perception, at least. It is true that you mentioned the difference of information in an activist campaign. For us, for example, the corporate has a significant competitive advantage compared to its shareholders. Why? Because the corporates has the capacity to identify at any point of time all its shareholders. They have the capacity to engage and talk to all their shareholders. The activist who want to make his arguments public, he cannot identify the shareholders, he doesn't know them, and it's much more difficult for him to reach the shareholders. So in terms of information, they have a massive advantage compared to the shareholders. The other point, which is key for us, And let's be fair, an activist campaign, it's expensive. It's expensive, because of the advisors you're going to take, lawyers, bankers, because of the marketing you're going to have to do. And once again, there's a massive discrepancy or differences with the corporate that can, use his balance sheet and the cash that he has to fund a marketing campaign compared to the fund, which is usually much more smaller in terms of size than the corporate and doesn't have the same financial means. The irony here, which is very interesting, is like when you think about it, the corporate is going to use the cash which belongs to the shareholders to defend himself against his own shareholders, which is pretty funny when you think about it.
Hi, good morning, and it's a pleasure to be here. Thank you very much for inviting me and having me participate on the panel. Just as a matter of good personal governance and transparency, the work that Sullivan and Cromwell does is generally focused, especially in the activist space, in defending against activism and preparing to engage with activists, and mostly on the corporate representation side. So there's probably some embedded bias in my views, but I'm going to be as objective as possible in the discussion today. I'd also like to put my views in context, and to do so, just wanted to flag some trends and some things that we've been seeing on the U.S. and where we think that means we're going in Europe and particularly in France. I agree that a lot of the campaigns in Europe have been more or less in the UK, but I do think there's some headwinds moving into France. Just in general, the trends have been that a lot of the money under management with quote-unquote activisms, and I like to reiterate the point that's been made a couple of times, what an activist is actually difficult in distinguishing between long-term investors versus short-term activist campaigns is a good point to make. But for example, out of the first half of 2019, I believe 45% of the capital invested in campaigns have moved into Europe versus last year, the first half of 2018, I think was 37%. 20% of that money has been in Europe, again, mostly in the UK, but I think anecdotally, the fact that Elliott, one of the leading activist funds in the US and a fund that a lot of other activists tried to emulate and follow along, have been active in France recently with Pernod. So I think, like I said, the trends are to see more and more activism moving into Europe and likely into France. I'd also agree that activism in general, when they are successful in their campaigns or successful in influencing positive governance trends and improvements in corporate governance and dialogue with shareholders, is fundamentally not on their shareholdings necessarily. A lot of them have small shareholdings, even under the thresholds that require disclosure, but their ability to be credible actors with other shareholders and their ability to be pose a credible threat to management in terms of pushing them on their strategic plans, short and long term, and their results is something that really is where their source of influence and power is. They also do very well when there's an asymmetry in information, and there's concerns that governance practices can be improved upon. So I think we've talked about the fact that there is a push for more transparency, more disclosure. In the U.S., there's a overwhelming amount of disclosure, whereas on other regimes such as France and Europe, Canada even, the amount of public disclosure about what companies are doing, their financial statements, updating in terms of material events is less comprehensive. Maybe in the U.S. it's a bit of an overload, so maybe we can curtail some of that and shift it over in other jurisdictions. The other trend that I think is important to acknowledge is that long-term investors, pension funds, BlackRocks, Vanguards of the world, they've taken up the mantle of pushing for social and environmental change, gender equality in terms of representation at boards and in the C-suite. And their, obviously, investment horizons and their policy views sync up and are aligned. So they generally hold their positions for, not forever, but for a long term, in their views on social and environmental matters, as well as good governance, are, being, traditionally they were engaging more quietly and behind the scenes. One thing that I think activists have done has pushed them to actually engage outwardly and with other shareholders and publicly. And the other thing I would like to say is that with all that in mind, I fundamentally have a lot of agreement with what's included in the position paper that's informed this panel discussion. And I think fundamentally there's a lot of attention to the negative that comes along with saying the word activism, but there have been positive knock-on effects, and I'd say that activism in general has really put good corporate governance discussions into the forefront and has created a lot more engagement on the subject matter. I'd also like to agree with a lot of the propositions that transparency actually helps solve for the issue and the notion that there's only a short-term financial concern amongst activists or institutional investors, and the idea to encourage more and better disclosure around financial statements, around executive compensation, will, I think, certainly allow for better conversations and engagement. And the other couple points I'd like to make is that excluding folks from the marketplace is not going to be the right solution, but allowing for mechanisms that allow for understanding and reducing agency costs and allowing participation amongst shareholders is going to be, I think, the avenue to encourage better corporate governance. That doesn't necessarily mean activists, the ones who are more short-term oriented, are going to be the saviors. I think just like every other market participant, they have a return on investment that they're focused on. But if we can work on and talk about the mechanisms to allow better dialogue, you're going to get a better result.
Thank you very much. So you both mentioned information. So maybe let's go back to this and transparency in general. So in the mission and in the suggestion that Clément Royo presented, there is this idea that the firm doesn't know enough, knows too little about its shareholders, and suggests to reduce the threshold to publicly file your position and more strongly enforce a deviation from the filing. But there is also the idea that you both floated that there is not enough information from the investor side, or that they operate with an information disadvantage compared to the company. So which effect do you think dominates? Do you think it's more the firm knows too little about its shareholders, or do you think that the investors know too little and then more transparency on the firm's action would solve actually, or make part of the campaigns useless? What do you think? And if so, what kind of information do you think should be made public, maybe mandatorily or through best practices? Maybe Olivier Fortesa, Mathieu Goodman, and then Clément Royo, you can respond to this.
Yeah, no, I think there is a discrepancy between the information the corporate has compared to the shareholders. They have the ability to identify owners of their shares at any time of time, so they can clearly map the entire shareholder structure, which obviously when you're a minority shareholders, you have absolutely no clue. Apart from the public disclosure, you have absolutely no clue of, who is a shareholder of the same company. And this is exactly why, by the way, the activist is going to try to make a public campaign, because as he doesn't know who are the other shareholders, if he makes his arguments public, he knows that the other shareholders can read them. Which, by the way, is an important point, because when the corporates are explaining that they don't know exactly what are the criticism about that the activists can make towards them, I'm only talking about us, okay? Our view is we always try to have a dialogue and a constructive exchange with the management, so we always make very clear what our thoughts are and what our view is. And the second point is when a campaign goes public, by definition, if it's public, the corporate has the same level of information about the activist arguments that any other shareholders.
I agree with a lot of that. I think on the activist side, or the investors that are agitating for change, the U.S. and France have similar thresholds for when disclosures need to be made. I think the consequences of failing to provide the adequate disclosure in France is a little bit more risky than in the U.S. If you fail on, for example, with 13D disclosures for tripping a 5% threshold in the U.S., or not updating your intentions in terms of what you plan to do with the stock, it's essentially the SEC gets mad at you. It's you update your disclosure, whereas my understanding here is that there's some potential punitive consequences if you don't meet your disclosure obligations. But I think it's fundamentally important that if there is going to be an agitation for change, whether positive or negative, and not a normative judgment on what a shareholder may or may not think is good for the company, I think those type of discussions should largely be transparent and in the public view, so that it's not the shareholder with a relatively small position but with outsized influence, encouraging management to make decisions that are not seen by the rest of the public float, who can make a choice in the marketplace to either stay engaged in the company or exit the investment and seek investments in companies who are committed to things that the shareholders themselves are interested in.
Yes, thank you. So on this issue, from what we heard from all the people we interviewed, is the idea that corporates are able to know exactly who their shareholders are at any point in time and in a very exact fashion. That's not what we heard, right? There are processes, there are the in French it's called the titre porteur identifiable, TPI. What we heard, and that was quite anonymous, and not only from corporates, right, is that no, you get a view, of course, it does help, but the view that you get is outdated, incomplete, and not entirely accurate. So the idea that they know exactly who the shareholders are, I think, is probably, from what we heard, not entirely right. On the idea that activist funds, or any funds or any shareholder, don't know what the other shareholders are in the company. Yes, that is true. Mostly, they can know. There are ways, and if you research, and some people do actually put a lot of money in research in that area. You can get an idea, but basically, yes, one shareholder doesn't exactly know who the others are, and that's the way it is. So the answer is yes. And when you say that when a campaign is public, then everybody has the same level of information. I don't think that's entirely true because, as you know, you don't, some people at least, from what we understand, don't put all the information they have, all the presentations they make, all the research they've been doing out there in the public, and they use, of course, some of it behind closed doors. So the idea that when a company is public, everything is known by everybody, I don't think is entirely true.
Thank you very much. So stepping back a little bit, we talk about like activists in France or in continental Europe in general, and most of the experience is based on like U.S. activists investing in the U.S. or in the U.K. With very different ownership structure, mostly widespread shareholders. How do you tackle this when you invest in continental Europe with mostly experience from the U.S. and the U.K., where you have widespread investors, and does it affect the quality of the dialogue in the 95% of the cases that are with fruitful discussions versus the 5% of the cases where you don't have fruitful discussions and you end up in a public campaign with a public public disagreement? And in this case, do you think that the minority shareholders' right in France are like too different than that in the US and the UK, or what's your opinion on this? Maybe again, Olivier Fortesa, Mathieu Goodman, and back to Clément Royo.
Yeah, so once again, from our experience, we invest mainly in continental Europe, so I can tell you some of the differences that we see between France and the rest of Europe. It is true, for example, that in Italy or Spain, you do have more protection for minority shareholders, and it's easier for a minority shareholder to get a board representation. Where, for example, in Italy, it's quasi automatic for a minority shareholder, and they can actually gather, several of them to ask for board representation, and the company cannot refuse it. It's automatic, and you have the same type of system in Spain. So it's easier in those countries to at least, put independent people that you think may play a role at the board level. There is one element which is key, because we're talking about dialogue between a shareholder and a corporate. Obviously, when you cannot agree and you have some major differences, one alternative, and that's the purpose of the activist campaign, is to go to a EGM or AGM and put some resolutions up for vote and see what the vast majority of the shareholders will do. But before you can reach that, there is one element we haven't discussed, which is the role of the executive board or supervisory board, because at the end of the day, they have a significant role and influence in terms of monitoring, controlling, supervising the management, listening to the shareholders, because at the end of the day, they are elected by the shareholders. And once again, from our experience, the 5% of the case where things got more on the defensive side or more on the aggressive side, we have always seen significant failure of the board. And in all those situations, it happens because the board is not playing its role, because the board members do not exercise any control over the management, and so you end up in this situation where maybe the management is not acting in the best interest of the shareholders. And this is key for us. That's one point that you mentioned. In an environment where everyone is focusing on ESG, the G is important. Showing a proper governance is key and fundamental, and obviously the basic for proper governance is a board that can fulfill his duty.
I'd like to pick up on a couple points that were made. I think the 95%, 5% kind of ratio is probably right, not scientific, but at least anecdotally. And I think that also is consistent with where we see good governance, where we see effective board members, board engagement, board supervision of the management team, and pushing and prodding management and executives to have a long-term, thoughtful strategic plan. Not that they're stubborn and don't pivot when things in the marketplace, macro or micro, change, but that they give the management a leeway to execute on their plan. I think it's 95%, and 95% of the time they'll engage with activists and other shareholders, long-term institutional shareholders who want to engage and push the envelope on trends or getting ahead of good governance practices. I do caution and I worry about focusing on the 5% and then the 5% really having the tail wag the dog, so to speak. And I think there's a lot of boards out there, especially in the U.S., because of a lot of class action lawsuits, a lot of fiduciary duty derivative lawsuits, where they are concerned about the litigation risk and they're concerned about their liability. Some of that's mitigated by D&O policies, the ability, which I don't think is the case in France, to exculpate your directors for certain duty of care breaches. So having an over-focus on the negative and the negative implications for the board and the consequences for them may steer them into being overly cautious or overly protective and not fully engaging and being transparent. So in terms of coming up with the right solution to some of these issues, I think it's important to make sure we're not having boards of directors looking behind them and being scared of their shadows of litigation or negative consequences, and letting them have some flexibility to do their job. But I totally agree that there should be dialogue, there should be engagement, and there's lots of positivity that can come from open conversations and giving shareholders an opportunity to make suggestions.
Do you want to add something, Clément?
Yes.
Okay.
Yeah, very very briefly. I think we can all agree, and this is one of the things that the congressmen have seen and have concluded, is that governance is key. I think when usually, not every single time, but usually when an activist engages with the company, there's some sort of improvement to be made. A good deal of times it has to do with governance, and I think we all know that. We've heard several people say, why didn't you put more emphasis, more focus in the report on good governance, the role of independent directors, and so on and so forth. We could have, but we wanted to focus on the phenomenon of activism rather than what drives them to a company, right? But we don't want this to be construed as we don't think this is an important issue, because it clearly is. Second point is, you talked about differences between countries. There's this, so the congressman went to New York to meet with several people, funds, activists, regulators, lawyers, and so on and so forth. And I think it was key to the understanding of the phenomenon and the way the report was written. Because if they hadn't gone there, it would have been a bit like if we were writing a report on skiing and haven't been to the mountain or haven't seen snow. Because this is the birthplace of activism is the U.S. And it was key, was pivotal for the congressman to have been to New York.
Thank you very much. So, going back a bit on this governance structure. So, you mentioned in the U.S. you have class action lawsuits, you have derivative lawsuits where you can name an individual executive for breach of fiduciary duties, which are very powerful legal actions that help small investors to coordinate ex post to discipline management or executives or board members' behavior, which could lead to some firms being too cautious. Maybe in France we're a bit on the other side of the tail, where we have much less legal legal actions available to small shareholders to simply coordinate. And as Olivier Fortesa mentioned, you always have the option to exit. If you disagree, you can just sell your shares. But how do you think of the quality of the voice option in France? Like, how much as a minority shareholders do you think that you have rights, and do you have enough rights to be heard? And do you think, for instance, that we should help this voice option by like dramatically decreasing the ownership threshold to put resolutions to a General Assembly, and whether this would prevent some activist campaigns by tackling issues much earlier on when they first arise? Maybe again, Olivier Fortesa, Mathieu Goodman, and then Clément Royo.
No, like the as the report clearly stated it, I think the toolkit for, if I can say that, for an activist in France or for a minority shareholder to express himself, that's the way I would phrase it, is good, and I don't think you need much more. I was saying that in some of the countries it may be easier to have access to the board and to have a board representative, a representative of the minority shareholders. That's one interesting point that maybe we could try to have in France. But in general, I think a minority shareholders has the tool and the ability to express himself. What's his key, once again, for me, is the G of ESG, is the governance and the role of the board. Because obviously, if the board doesn't play ball with the shareholders, then you can end up in this dead end where the communication is failing and the board is not receptive to the demand of the shareholders. So that's key. I don't think you mentioned it, that the reason why I don't think that the board members are afraid of their shadows in France for potential litigation. I think, like you mentioned it, we're much more on the end tail of that trend in France. One of the issues that you may have in France is the fact that board member is becoming a job, is becoming a profession. And, if you want to be able to accumulate several board member positions, it is best that you're not too vocal or too critics towards the management in the boardroom. Otherwise, obviously, you won't be recommended for another board position. So that's an issue that we may face in France and in other European countries.
Yeah, and just to qualify something I said before, I think it's important that you balance the outside threats or pressures and outside influences on board members and managers. So we do have class action lawsuits, which will obviously have some pressure on how potentially you think of your decisions as an individual actor. But then at the other hand, we do have more protections and limitations on the type of liability board members. So I think that pushes board decisions into a place where they feel free to diligently make decisions and inform themselves and have the right answer. So it's not a perfect equilibrium, but I think if you're going to encourage directors to think independently and make the right decisions for the corporation or the shareholders or the broader environment, you need to give them something on both ends. You can't just have them feel overly comfortable, which I think is a theme from some of this discussion that's happening in France. But you also can't you can't put external factors and short-term factors to weigh too heavily against them. On some of the other kind of points that we've been discussing, I do think that giving minority shareholders a bigger voice or having their concerns heard is going to be an important factor. And just to be honest, the U.S. hasn't solved this problem. It's a very fluid, ongoing issue. The ability for shareholders to have resolutions proposed at annual shareholder meetings is an ongoing debate. There are certainly thresholds in the U.S. That have been put in place. There are lots of advanced notice bylaws, which essentially are procedural hurdles, which make it potentially harder for minority shareholders to get, even if they have the right amount of equity in the company. There have been some recent cases where there's just a complete technicality on the part of the minority shareholder agitating for a shareholder proposal. The meeting, their proposal isn't going to make it to the annual meeting and in the proxy statement because they had basically a technical foot fault on some of the things. So we in the U.S. haven't solved all these problems, and there's certainly room for improvement. But I do think, the mechanisms to make sure that if you're a publicly listed company, NASDAQ and IC have independent requirements. There's some exceptions, but generally have an independent voice in the room and making sure that there are fiduciary duties from a state law perspective, and there are some abilities for shareholders to challenge those decisions are fundamental to the overall landscape.
Okay, then maybe more to Olivier Fortesa. So if board members is maybe becoming too much of a profession in France, do you think that the increase in activist campaigns that's coming to continental Europe is going to be enough to change this and make boards more able to deal with management? Or do you think that there's more a call for regulation? We know we're already a heavily regulated financial market, but what do you see campaigns being an effective tool in changing the equilibrium for most firms in the long term?
I think that if you look at it, I mean, you're the expert here, but you've from what you've shown us, you've looked at past campaigns. One of the main objective in all those campaigns is usually to change the governance and usually to change the board, because once again, if the board has a significant role in controlling and implementing the strategy with the management. So if you disagree with the management and the management won't listen to you, the board is the only alternative. So I think it has been key, and it will continue to be for the activist one objective, implement better governance. In France, we have this debate of what is an independent board members, and it's important to have independent board members. I don't think you can regulate that. From our experience, once again, we do like non-independent board member. What I mean by that is board members that have skin in the game. Okay, so they are shareholders. They represent like a family ownership, for example, in the board, and so they have a full alignment of their interest with the shareholders because it's their money that they have in the company. The issue that you may have with some of the independent board members, and once again, it's a very general topic, but in some of the cases, they are so independent that they're completely cut from the reality or the interest of the shareholder, which becomes problematic. One solution that has been proposed in France, for example, is to ask the board member to have more shares, more skin in the game in the company, just to make sure that he's fully aligned with the shareholder, which may be part of the solution. But anyway, I don't know if there's a way to regulate this. I don't think so. It's at the end of the day the duty and the role of each individual that is going to fulfill his job and try to do it properly or not.
Thank you very much. So maybe as a last point for this roundtable, we talk about activist campaigns trying to come to maximize the value of the firm, and then what should they maximize? Are they maximizing the value for everyone or just for themselves in the short term, which is part of the tension around activist campaign? But this general framework is a bit evolving with discussion in the Loi Pacte, in the Pacte of Regulation in France, discussing the broader social purpose of the company, of the firm in France, and the parallel overall discussions in the United States occurring right now on are we going beyond the pro shareholder model? Are we simply maximizing the value for the shareholders, or are we internalizing other factors or other stakeholders. Do you think that this is going to affect the way we see activist campaigns, both in the United States and in Europe? And what do you think? What direction this could be taking or affecting the capital markets? Maybe Matthew Goodman, if you want to start on this before Olivier Fortesa takes over.
Yeah, so in terms of the broader focus on stakeholders, there's, as you mentioned, there's this ongoing debate, and it's in some ways it's very new, and in some ways it's very old. Lots of the U.S. legal system in terms of corporate regulation and legislation is in very federalist, right? There's a lot of federal laws in terms of federal security laws and disclosure laws, and there's state by state corporate statutes. And a number of states have, for a very long time, are built into their mechanisms a larger stakeholder perspective on boards. It's most of the companies are incorporated in Delaware, where the thesis for a long time had been, or the view had been for a long time, that it's a focus on the shareholders and shareholders alone. If you choose to think about other stakeholders, that's perfectly legitimate, but there was an overwhelming focus on shareholders themselves. Some people are now saying, well, in order to focus on the shareholders and the company's long-term health, you do need to think about the larger stakeholders and the environment and all these things, because if you're irresponsible with certain social and environmental practices, that will have an impact on the long-term health of the company, and will have a long-term impact and maybe even shorter impact on some of the shareholders. So I think it's important to think about those avenues, and I think the recent legislation in France in putting that into the legislative landscape is going to open up a discussion and have room for shareholders to debate whether management and whether the board is really focused on what's best for the company, what the corporate purpose is, and whether they're living up to that, and whether their long-term strategic plans are aligned with those purposes.
I think it's important, obviously, to look at all the stakeholders, but my standpoint is if the company is in a good health, invest in its business, have a clear strategy, this is going to be reflected into the share price. This will attract shareholders. So trying to differentiate, the objective or return of shareholders compared to other stakeholders, I don't think that's the way we should approach it. I think it's a common objective that all the stakeholders have, and if the company is delivering, it will attract investors, and the share price will go up on the long term. So maybe not obviously on the short term, but on when you look as an investor, mid-term to long-term investment in a company, it will be reflected in the share price.
Thank you. Yes.
A couple of words. Yeah. So when the congressman and I were in New York, we were introduced to this debate about social purpose, who say raison d'être in French, and we discovered that the extent of the debate going on in the U.S. with very prominent figures such as Martin Lipton pitching in. That was quite interesting to see how this is unfolding in the U.S. So following what we've been doing in France. So maybe for once we're in front on the matter. Let's see how this unfolds. At one point, I was talking to someone about what is an activist, what's not an activist, and one of the remarks I made is that if you go up in the street, or maybe not in France because there's a language issue, but if you go in the street in the US and say, what do you think about activists? The answer, you're going to get an answer, I think. People will say something, but they won't say something about, hedge funds or what have you. They will talk about environmental activists or social activists, but I mean, the term activist will speak to them. It will not mean what we're discussing today, but it will mean something to them, right? And I think this is significant somehow, because somehow the definition of an activist is somebody that speaks up to change things in the long term. And coming back to the debate about short term and long term, I think the fact that activists are a growing force, they have been for some time in the US, they're a growing force in Europe and in France in particular, there are changing things in the long term, in the way we see governance, in the way board function, in the way companies behave themselves towards the shareholders. And I think this conference and the discussions we're having right now is actually a tribute to that.
Thank you very much. So maybe a couple of words to conclude us on this roundtable. We see an increase in activist campaigns in continental Europe, and the trend is probably going to pick up and become much more pronounced, with mostly the intention to improve the functioning of the companies and the value and the value in the long term. And I think we all agree that like the report that you presented was very fair and was coming with some soft law recommendation and best practices that will help investors communicate with the firm and the firms communicate and know who their investors are, to make sure that the dialogue is productive and avoid maybe more public costly campaigns that will not result into positive changes. Thank you very much all for your participation and for coming in today. Thank you very much.
Before to take a short break, if you have some question, there is some mic. Before to talk, can you introduce you?
En anglais, en français. Hi, so my name is Jérôme Amon. I work at Egon Zehnder. I lead the board advisory practice. I have a couple of questions on governance and boards, which was a big part of your presentation today. I think the first question is for Thomas. So an important part of the debate is around the role of the board and the role of board members. Yet, Thomas, in your presentation at the beginning of the discussion, when you talked about prevention mechanisms for activist campaigns, so you mentioned better communication for strategy. You mentioned the fact of decreasing capex and increasing dividends, but you did not mention as a prevention mechanism the fact of having a better board and preparing for a more efficient board. So I was wondering why that was. That's my first question. The second question for the rest of the panel is, you mentioned several times the necessity to have an effective board, to have an effective team, and have effective board members. What's your definition of an effective board member? You said that they should be cautious with liability. You said that they should be independent or non-independent, but you did not mention what was an effective board member. So I was curious about that. Thank you.
Okay, so I'll respond to the first part, which is technical, so it's an easy one. So the reason these papers, then the one I wrote, don't look at like changing governance, is the way we measure the risk of being targeted is if you have a peer firm, like a close firm in your industry being targeted, and we can pick up rumors that you would be targeted right after because the problems you face are similar. But this is like on a very short-term period. If at the end of Q1 you think that you'll be targeted next quarter, you can announce a change in your dividend policy, you can announce a change in your investment policy, you can disclose much more information about your value proposition and how you think your strategy is going to evolve next in the future. But it's very hard between Q1 and Q2 to dramatically modify the structure of your board. So I agree, this can preempt a campaign. It's just harder to implement in the short term. You have only one occasion a year, and you cannot even change for most companies the entire board at once. I'll let who wants to define an effective board member. Olivier Fortesa, you want to?
I'll try. I'm not going to define an effective board member, but I'll try to answer the question. First statement is we can all see the difference between what is an effective governance and, identify a company where the governance is not working. It appears loud and clear. I don't know if you have a proper definition. The thing that we are looking for as an investor is a board that is receptive and in contact with its shareholders. So he has, as part of his duty, the idea or the concept of creating value for the shareholders and protecting the shareholders. And the second part we're looking for, because that's the same question about the dialogue. It's to be able to monitor, control, exchange, supervise the management. Okay, that's key. So you need to see this interaction with the management, and we as a shareholder need to know that the board is actually challenging the management. And we all hope that out of this, fruitful dialogue and exchange will come out a better strategy or good strategy for the company. The failure that we have identified is that when the board is not challenging the management, and basically the management can do whatever he wants, and the board is just not doing his duty.
Just to add a few points, I don't think you could divorce the question of what makes a singular effective board member from what makes an effective board in general. It is a unit that's comprised of its parts, and I do echo a couple sentiments, which is you need them to be engaged, you need them to be critical thinkers. So one trend that's been an issue recently in the US is overboarding, and so ISS, Glass Lewis, along with other sources of good governance criticism and input, have focused on having limits on how many boards you can sit on, and they bifurcate between whether you're an executive or you're non-executive. So I think having time and space and the ability to focus on the concerns of the company, having the right amount of industry experience, the right amount of financial knowledge as an individual is important. But collectively, you need lots of different perspectives. So I think focusing on differences and focusing on having a representative board, just like people like having representative democracies, is important for an overall effective board, because I just don't think you could actually have a individually effective board member and in a singular person, right? You need everyone to work together to have an effective governance mechanism.
Yes, this goes beyond of course, the scope of the report, but I think one of the there are some people in the last 10 years who have devoted a lot of thought on this particular topic: what makes an effective board member, what makes an effective board, and I agree it's not exactly the same. How many mandates can you hold, so on and so forth, and it's in the area of banking and insurance. You do have now regulations implemented in France, in Europe, about what actually makes a good board in a bank or an insurance company. There are limitations about how many mandates you can hold. There's a lot of work being done by supervisors on what actually they have to think about when they have to stamp the appointment of a board member, or even the functioning of a board. And this goes all the way down to behavioral issues being tackled by the banking supervisor. So I think if lessons are to be learned somewhere, it's probably in the banking and insurance supervisory space.
So we have time for one more question.
Bonjour, Frédéric Pelletier, avocat. Je vais m'exprimer en français parce que autant je suis favorable à l'internationalisation du capital des entreprises françaises, je voudrais que ça se fasse en épargnant la langue française si possible le plus souvent. Et puis, comme je vais m'adresser plus aux représentants du président de la Commission des finances de l'Assemblée nationale, je trouverais incongru de discuter avec lui en anglais. Je pense que Olivier Fortesa a soulevé un véritable problème qui est le problème de la connaissance par les actionnaires de leurs pairs, qui sont les actionnaires, en fait. Les actionnaires ont du mal à savoir qui sont les actionnaires, parce que, pour diverses raisons d'ailleurs, parce que les feuilles de présence ne permettent pas d'avoir une bonne vision de l'actionnaire, l'accès au TPI est assez problématique, et finalement, moi qui conseille souvent des sociétés ou des actionnaires actifs ou activistes, je vois bien qu'il y a, et il faut le reconnaître, une inégalité des armes. Quoique le terme arme pose un vrai problème, parce que lorsqu'on parle d'armes, c'est la guerre, et la guerre, c'est la destruction de valeurs pour les entreprises et pour les actionnaires. Donc il faut absolument éviter d'en venir aux armes, et pour en venir aux armes, il faut essayer d'aller vers des consensus. Alors ce que je voudrais dire, s'agissant donc de cette problématique de la connaissance des actionnaires, Olivier l'a bien dit, il n'y a pas d'autre recours pour un actionnaire qui veut savoir ce qu'il pense d'une stratégie qu'il voudrait modifier ou d'un board qu'il voudrait recomposer que de faire le buzz, c'est-à-dire que de communiquer. Or, lorsque l'on fait le buzz, c'est vrai que tout de suite on se dit « Ah, mais est-ce que ça n'est pas un buzz spéculatif ?» C'est-à-dire, est-ce que ce qui est écrit n'est pas là uniquement pour faire monter le cours ou pour le faire baisser et servir une stratégie d'investissement? Ce qui est un vrai problème. Et le cœur du problème, il est là, je pense, sur l'activisme. Alors, je trouve que la solution qui est proposée par votre rapport, que malheureusement nous ne connaissons pas encore parce qu'il n'est pas public, ça c'est comme un vrai problème aussi. On en parle beaucoup, mais on ne sait pas vraiment ce qu'il y a dedans. Mais a priori, vous proposez la réduction donc du premier seuil de déclaration légale de franchissement de seuil à 3%. Je pense que les déclarations de franchissement de seuil, ça n'est pas fait pour défendre les entreprises contre leurs actionnaires qui veulent s'exprimer. Les déclarations de franchissement de seuil, ça a été conçu pour connaître l'actionnariat et les prises de contrôle rampantes ou non rampantes, et c'est ça l'objectif de la déclaration de franchissement de seuil. Et je ne pense pas qu'en baissant le seuil, les actionnaires connaîtront mieux leur pairs et la composition du capital. À mon sens, une vraie mesure sur laquelle il faudrait réfléchir, et Olivier l'a également évoqué, en disant que les sociétés dépensent de l'argent, et c'est bien normal à mon sens, pour discuter avec leurs actionnaires, pour les convaincre dans souvent soit des roadshows, mais également dans ce qu'on appelle des one-to-one. Or, moi, je pense qu'une mesure simple serait d'imposer aux sociétés de tenir un registre des contacts qu'elles ont initiés ou qu'elles n'ont pas initiés avec leurs actionnaires qui, par exemple, détiendraient une position de 0,5% du capital. C'est exactement d'ailleurs dans la logique de ce que vous connaissez à l'Assemblée nationale, qui consiste à tenir un registre des personnes qui vont voir des députés pour défendre une cause, etc. C'est quelque chose qu'on voit donc qui se répand. Hein. Et si ce registre des relations entre la société et ses actionnaires est accessible en permanence par les autres actionnaires, eh bien vous avez ici un élément de connaître à la fois, d'avoir une photo, je dirais, c'est plus qu'une photo d'ailleurs, c'est un film de l'actionnariat des sociétés et qui permet à tout le monde à la fois de connaître un peu mieux sans avoir accès à un TPI, qui est quelque chose d'ailleurs qui coûte cher et puis qui n'est pas toujours efficace, mais d'avoir une vision claire de l'actionnariat et qui permet de rétablir cette connaissance, puisque les activistes pourraient alors, vous avez parlé de contradictoire, apporter la contradiction à la société, au management, sur ce qui a pu être dit à ses actionnaires.
Oui, merci. Je suis ravi de m'exprimer en français. Vous avez beaucoup de choses intéressantes, certaines avec lesquelles je suis évidemment tout à fait d'accord. En revanche, je suis pas sûr d'avoir... je veux bien faire une réponse, mais je suis pas sûr d'avoir retenu exactement une question. En revanche, bon, sur la baisse du seuil, si, ça vous donne une meilleure connaissance, c'est pas la panacée, c'est entendu, mais ça vous donne une meilleure connaissance. Les gens qui sont entre 3 et 5, quoi, tout simplement. Ça va pas beaucoup plus loin que ça. Voilà. Pour le reste, tout ce qui peut aller dans le sens de la transparence, est évidemment, une bonne chose. Alors, on m'a demandé de faire court, on pourra poursuivre ça derrière si vous voulez.
Bon, on va encore prendre une question, deux, on verra, mais dans ce cas, je vous demande de faire des questions très très courtes et d'avoir des réponses courtes.
Merci. Sébastien Thévout, comme geste. Ce matin, le président de l'AMF a évoqué quelque chose qui existe à Londres, qui s'appelle l'Investor Forum, et qui, sans en être peut-être, enfin la solution à tous les problèmes qui ont été évoqués depuis ce matin, pourrait être une grosse partie de la solution. À la fois, ça pourrait être effectivement une plateforme pour essayer de résoudre les problèmes en amont, avant que ces problèmes de gouvernance ne s'aggravent au point où parfois des activistes sont obligés d'intervenir. Et en même temps, ça peut aussi faciliter le travail d'un activiste, entre guillemets, qui aurait peut-être un écho un peu plus facile à avoir auprès d'un groupe d'investisseurs, plutôt qu'effectivement mener ces one-on-one et éventuellement avoir des discours qui changent un tout petit peu parce que les conversations ne sont pas toujours les mêmes durant ces rencontres. Et en France, on n'a pas ça, alors que on aurait effectivement potentiellement énormément intérêt à le mettre en place. Alors c'est pas facile de trouver le lieu où cet Investor Forum pourrait apparaître, parce que bon, en Angleterre, on voit quelle en a été la genèse. Ce ne serait pas évident d'avoir la même chose en France, mais je voulais savoir si M. Royo a été confronté à la question de l'intérêt de créer les conditions d'un Investor Forum en France.
La réponse est très simple, non. Non. En revanche, qu'il y ait des initiatives privées qui cherchent à mieux faire communiquer les entreprises, leurs actionnaires, les actionnaires entre eux aussi, c'est évidemment une bonne chose. Et c'est l'esprit, même si c'est pas quelque chose qui, stricto sensu, a retenu notre attention, c'est évidemment dans l'esprit du rapport.
Et on prend une dernière question. Bon. Ah.
J'ai une rapide question pour Monsieur Royo, le roi Proxinvest. Je voulais savoir si vous avez connu les travaux de l'AMF sur la modernisation et la réforme de votre Access, qui est un système complètement fermé dans lequel il n'y a aucune communication aux adresses Internet. Et si vous voulez, à partir du moment où déjà le système des émetteurs officiels, autorisé par les systèmes bancaires, ce système est paralysé et fermé, comment voulez-vous que les actionnaires puissent avoir quoi que ce soit d'accès à ce truc-là? Déjà, même les émetteurs ne l'ont pas. C'est-à-dire qu'on a, dans votre Access, un système qui a été dominé par une volonté des banquiers de paralyser l'information pour la garder chez eux. De ce fait, si vous me permettez, les émetteurs ne peuvent absolument pas communiquer avec les investisseurs, réciproquement évidemment, et l'AMF avait fait un travail assez sérieux de réforme là-dessus. J'aimerais que vous ayez la chance de pouvoir le voir.
Écoutez, si vous avez la gentillesse de me le communiquer, je le regarderai avec intérêt.